Pre-trial discovery. Hi, I'm Doug Landau. I'm a lawyer with Abrams Landau Limited here in Herndon, Virginia, located a few minutes from Washington Dulles International Airport and 20 miles due west of the White House. We're going to talk today about pretrial discovery. What is it? Pretrial discovery is the process where the injured individual and their lawyers and the defendant and their lawyers find out each other's story, collect evidence, get witnesses and exhibits, and basically discover all that they can so that when they get to trial, there's no surprise. As the old hotel commercials used to say, the best surprise is no surprise. Pretrial discovery can consist of a number of tools that a lawyer can use to find out the facts of a case. These include something called interrogatories, which we'll discuss in another video. These are written questions under oath that one side can ask the other. They are requests for production, meaning just that. One side asks the other side to produce documents, records, photographs, and other tangible evidence that they might use at trial or that might be discoverable. It can include a tool called requests for admissions, which we like to use to get the other side to admit facts that we really shouldn't be fighting about, or that records are true and accurate copies, or reasonable in amount, or related to the event. Another tool at the lawyer's disposal is something called depositions. It doesn't mean someone's going to be deposed and their head's going to be cut off. It simply means that they are going to be asked questions, again under oath, by the other lawyer, with a court reporter present writing everything down so that they can't change their story later, and if they're unavailable, that testimony might be used in lieu of their live testimony at trial. Very often depositions are videotaped so that the video can be edited and played for the judge and jury, and or used at mediation or arbitration. Another tool in pretrial discovery that defense lawyers seem to like a lot is something called motions or motions practice, where they bring a motion to compel more complete answers, full answers, additional documents, or other relief from a court. And in addition, pretrial discovery can include such things as a visit to the scene where the injury occurred, and our firm has done that in all sorts of weather and all sorts of locations. Sometimes it requires a motion and a pretrial order giving you permission, or when we investigate airport or airline injury cases, a safe conduct pass to go into the secure or sterile areas. These things are important because if records are not exchanged during the pretrial discovery process, they may not be introduced at trial. These things are important because if someone gives a different answer under oath in their written interrogatory answers, and then a different answer at their oral deposition under oath, and then a different answer at trial, the other side can try to show that they're not being candid, they're dishonest, they're deceitful, and it could be perjury, which is the legal word for lying under oath, and it's serious. Pretrial discovery is important also for the court so that a judge before trial can know what facts and what evidence will be coming in and how long the trial will take. A case with thousands of pages of relevant medical records and bills and wage loss information will take longer than a case with only a few pages of similar information. So what are the takeaways? The takeaways are, number one, it's important to work closely with your lawyer and their staff to prepare for each of these discovery tools. It's important as an injured person for your side to get your requests out immediately upon the filing of a lawsuit so you're not playing catch up. It's important that you actually read your answers to interrogatories, your responses to requests to produce or requests to admit, and that you're familiar with what evidence will be in your case and what evidence will not be in your case. It looks very bad when someone at their deposition says, I didn't see my answer to interrogatories, I did not say that, my lawyers wrote it, and yet it happens a lot. Make sure that you meet with and prepare with your legal team for your deposition because, as has been said in the past, deposition testimony is trial testimony. And lastly, make sure that you understand the tools in the process, that you're comfortable with what is happening, and that you have the advice of an experienced trial lawyer who actually goes to court and tries injury cases. Again, I'm Doug Landau. I'm a lawyer at Abrams Landau Limited here in Herndon, Virginia, located minutes from the Washington Dulles International Airport and 20 miles west of the White House. And we hope that this has been helpful to you. Thank you.